Symphony Orchestra concert. We hope you can join us. Good morning and welcome to Schuler Auditorium. Before we start, we ask that you please turn your ringers to your cell phones and pagers off at this time. Thank you. We now continue our journey in search of personal freedoms. The end of legalized segregation, Brown versus the Board of Education, 1954. Ladies and gentlemen, please rise and remain standing for the Justices of the Supreme Court.
Ladies and gentlemen, please allow me to introduce the members of the Supreme Court. Robert H. Jackson, Stanley F. Reed, William O. Douglas, Felix Frankfurter, Harold Burton, Hugo L. Black, Tom C. Clark, Sherman Minton, and I am Chief Justice Earl Warren. The case before us today is Brown versus the Board of Education of Topeka, Kansas. Today's hearing combines the cases from the state of Kansas, South Carolina, Virginia, and Delaware. I recognize Mr. Thurgood Marshall, Chief Legal Counsel for the plaintiffs, the National Association for the Advancement of Colored People, on behalf of Miss Linda Brown and her father, Oliver Brown. Welcome, Mr. Marshall. I also recognize Mr. John W. Davis, Chief Counsel for the defendant, South Carolina, as well as the adjoined states. Welcome, Mr. Davis. Mr. Marshall, you are recognized by the court for 30 minutes to present the plaintiff's case.
May it please the court, Thurgood Marshall, appearing on behalf of the appellant Harry Briggs, Jr. et al. Versus R.W. Elliott, Eastern District of South Carolina. I will be addressing the arguments of these parties, and my colleagues will present oral argument of the other litigants, Brown versus Board of Education, Topeka, Kansas, Davis versus County School Board of Prince Edwards County, Virginia, and Gephardt versus Belton, Delaware. In Briggs versus Elliott is presented the question of whether the government, by its endorsement of segregation, is promoting self-hate in Negro children. The NAACP claims that school segregation is unconstitutional and that the failure of a state to provide equal educational facilities to some of the citizens solely because of their race or color is a violation of the 14th Amendment of the United States Constitution. My question is, how does this court reconcile the U.S. Constitution and Article 11, Section 7 of the Constitution of South Carolina, which provides, and I quote, "separate schools shall be provided for children of the white and colored races, and no child of either race shall ever be permitted to attend a school provided for children of the other race," end of quote. In addition to Section 5377 of the Code of Laws of South Carolina is as follows, and I quote, "It shall be unlawful for pupils of one race to attend the schools provided by boards of trustees for persons of another race. End of quote. Legally enforced racial segregation in the public schools of Kansas, South Carolina, Virginia, and Delaware denies the Negro children of these and other states that equality of educational opportunity and benefit required under the Equal Protection Clause of the 14th Amendment. South Carolina, like the other states in this country, has accepted the obligation of furnishing the extensive benefits of public education. Article 11, Section 5 of the Constitution of South Carolina declares, and I quote, "The General Assembly shall provide for a liberal system of free public schools for all children between the ages of 6 and 21 years." Some 410 pages of the Code of Laws of South Carolina deal with education. Provision is made for the entire state-supported system of public schools, its administration and organization, from kindergarten through the university. Pupils and teachers, school buildings, minimum standards of school construction, and specifics requiring certain general courses of instruction are all dealt with in detail. In addition to requiring that the 3 R's must be taught, the law compels instruction in morals and good behavior, and in the principles and essentials of the United States Constitution, including the study of and the devotion to American institutions. The public school, even more than the family, the church, business institutions, political and social groups, and other institutions have become an effective agency for giving to all people that broad background of attitudes and skills required to enable them to function effectively as participants in a democracy. Thus, education comprehends the entire process of developing and training the mental, physical, and moral powers and capabilities of all human beings. Expert witnesses in this case have testified that compulsory racial segregation in elementary and high school inflicts considerable personal injury on the Negro pupils, which endures as long as these students remain in the segregated schools. These 9 expert witnesses testified that compulsory racial segregation in the public schools of South Carolina injures the Negro students in 6 specific ways. 1, impairing their ability to learn. 2, deterring their development of their personalities. 3, depriving them of equal status in the school community. 4, destroying their self-respect. 5, denying them full opportunity for democratic social development. And 6, subjecting them to the prejudices of others and stamping them with a badge of inferiority. Dr. Kenneth Clark, one of the appellant's experts in the fields of social and child psychology, who testified and tested the infant, plaintiffs, and other Negroes, school children, states, these children in Clarendon County, South Carolina, like other human beings who are subjected to an obviously inferior status in the society in which they live, have been definitely harmed in the development of their personalities. That the signs of instability in their personalities are clear, and that every psychologist would accept and interpret these signs as such. this kind of injury, which would be as enduring or lasting as the situation endured, changing only in its form and in the way it manifests itself. The humiliation that these children have been going through is a type of injury to the minds that will be permanent as long as they are in segregated schools. Not theoretical injury, but actual injury. The appellees, nor the trial court, took note of the testimony of the NAACP's 9 expert witnesses. I do not know what clear testimony we could produce as an attack on a specific statute as applied to a specific group of appellants. The record in this case presents for the first time in any case competent testimony of the permanent injury to Negro elementary and high school children forced to attend segregated schools. Testimony was introduced showing the irreparable damage to the appellants in this case solely by reason of racial segregation. The record also shows the unreasonableness of this racial classification. This evidence stands uncontradicted in the record. The state of South Carolina presented no expert witnesses to refute this testimony. In addition, these witnesses have shown that there is no real difference in the ability of white and black children to learn. Therefore, the South Carolina laws classifying and segregating school children by race had no basis in reason or law, and has also proven very harmful to the black children. In this case, the state presented 2 fact witnesses. One, to persuade the court that the South Carolina legislators' recently created commission would address the concern. The other, aptly named Mr. Crow, to testify that segregation was not harmful because new facilities would be built. It is of no small matter that the established rule of the law of South Carolina, that it is libelous per se to call a white person a Negro. This attack on behalf of Briggs et al. Is not being made on the Plessy versus Ferguson 1896 separate but equal basis of the facilities, the physical facilities. But the position we are taking is that these statutes are unconstitutional in their enforcement because they do not only produce these inevitable inequalities in physical facilities, and that evidence produced by expert witnesses show that the governmental imposed racial segregation in and of itself is also a denial of equality. We are saying that there is a denial of equal protection of the laws. The legal phraseology of the clause in the 14th Amendment, and not just this point as to equality. And I say that because I think most of the cases in the past have gone off on that point of whether or not you have substantial equality. The compulsory segregation laws of South Carolina infect its public schools with that racism which this very court has repeatedly declared unconstitutional in other areas of governmental action. During the past quarter century, this court has consistently held that the 14th Amendment invalidated specific state-imposed racial distinctions and restrictions in widely separated areas of human endeavor. Cases involving ownership and occupancy of real property, Shelley versus Kramer, Oyama versus California. pursuit of gainful employment or occupation, Takahashi versus Fish and Game Commission. Selection of juries, Shepard versus Florida, Payton versus Mississippi, Pierre versus Louisiana, Hale versus Kentucky, and graduate and professional education, McLaren versus Oklahoma State Regents, and Sweat versus Painter. Although these Sweat and McLaren cases arose in the field of higher education, the constitutional issue is the same at every level of public education. Does state-imposed segregation destroy equality of educational benefits? We are taking a broad reading to the interpretation of the 14th Amendment in the Sweat versus Painter and McLaren versus Oklahoma State Regents decision of 1950 as a culmination of the court's long retreat from the Plessy Doctrine, upon which the southern states had long enacted laws to segregate the races from cradle to grave. The Sweat and McLaren cases teach not only that this is the issue which must be resolved in every case presented for judicial review, but also that in seeking the answer, the court will consider the educational process in its entirety, including and apart from the measurable physical facilities, whatever factors have been shown to have educational significance. And where the record shows that segregation is a major handicap to education, the court will hold that the difference in treatment is a type of state-imposed inequality, which is prohibited by the Equal Protection Clause of the 14th Amendment. Public, elementary, and high school education is no less a governmental function than graduate professional education in state institutions. Moreover, just as Sweat and McLaren were denied certain benefits characteristic of graduate and professional education, it is apparent from this record that appellants are denied educational benefits which the state itself asserts are the fundamental objectives of public elementary and high school education. A state legislative classification violates the Equal Protection Clause of the 14th Amendment, either if it is based upon non-existent differences, or if the differences are non-reasonable, related to a proper legislative objective. Classifications based on race or color can never satisfy either requirement and consequently are the epitome of the arbitrariness in legislation. Segregation of Negroes, as practiced here, is universally understood as imposed on them a badge of inferiority. Segregation brands the Negro with the mark of inferiority and asserts that he is not fit to associate with white people. South Carolina has made no showing of an educational objective that racial segregation subserves, nor could it. Efforts to conjure up theories of intellectual differences between the races are futile. The conclusion accords with all the scientific investigations on the subject. Kleinberg, race differences. Montague, man's most dangerous myth, the fallacy of race. American Teachers Association, the black and white of rejections for military service. Kleinberg again, Negro intelligence and selective migration. Peterson and Lanier, studies in the comparative abilities of whites and Negroes, mental measurement monograph, and Clark, Negro Children, Educational Research Bulletin, Los Angeles. The Constitution and Code of South Carolina requiring racial segregation in education are no more capable of surviving constitutional onslaught than the invidious classification legislation previously voided by this very court as repugnant to the constitutional guarantee of the Equal Protection of the laws. Plessy versus Ferguson is not applicable here. The Plessy ruling, upholding the Louisiana 1898 law segregating blacks in interstate railroad trains, was a judicial aberration. Whatever doubts may once have existed in this respect were removed by this court in the Sweat versus Painter. It is time to meet the Plessy doctrine head on and to declare that doctrine erroneous. Candor requires that the plain purpose and effect of segregated education is to perpetuate an inferiority status for Negroes, which is in America's sorry status for slavery. The primary purpose of the 14th Amendment was to deprive the state of all power to perpetuate such a caste system. The history of segregation laws reveals that their main purpose was to organize the community upon the basis of a superior white and an inferior Negro caste, a status as close as possible to that had he held before the Civil War. Inevitably, segregation has meant inequality, consistent only with the belief that the people segregated are inferior and not worthy or capable of enjoying the facilities set apart for the dominant group. The separate but equal doctrine furnished a base for those who sought to nullify the 13th Amendment. It is our theory that this case resolves itself simply to this: whether the separate but equal doctrine is still the law. We are saying that there is a denial of equal protection of the law. The evidence both in Congress and in the legislatures of the ratifying states reflects the substantial intent of the amendment's proponents and the substantial understanding of its opponents that the 14th Amendment would of its own force proscribe all forms of state-imposed racial distinctions, including all racial segregation in public schools. Without the constitutional sanction which Plessy versus Ferguson affords, racial segregation could not have become entrenched in the South, and individuals and local communities would have been free to maintain public school systems in conformity with the underlying purposes of the 14th Amendment by providing education without racial distinctions. But for this doctrine, we could more confidently assert that ours is a democracy based upon a belief in individual equality. When a state statute is tested, it is not tested as to what is reasonable insofar as South Carolina is concerned. It must be tested as to what is reasonable as to this court. It seems to me that in a case like this, that the only way that South Carolina, under the test set forth in this case, can sustain that statute is to show that Negroes, as Negroes, all Negroes, are different from everybody else. Negro children have had roadblocks put up in their minds as a result of this segregation, so that the amount of education that they take in is much less than other students take in. The lower courts ruling that school racial segregation was a legislative matter for each state to decide runs counter to U.S. Supreme Court opinions and to the intent of the framers of the 14th Amendment. So here we have the unique situation of an asserted federal right, which has been declared several times by this very court to be personal and present, being set aside on the theory that it is a matter for the state legislature to decide, and it is not for this court. And that is directly contrary to every opinion of this court. I think that when an attack is made on a statute on the ground that it is unreasonable classification and competent, recognized testimony is produced, I think then that the least that the state has to do is to produce something to defend their statutes. Your Honors, inferior schools and resources are not the issue. It is segregation itself. The state has an obligation to integrate its schools. All Negro parents want is for state segregation laws to be ruled unconstitutional. In light of the foregoing, we respectfully submit that appellants have been denied their rights to equal educational opportunities within the meaning of the 14th Amendment, and that the judgment of the court below should be reversed. The plaintiffs call for immediate relief by a direct order from the U.S. Supreme Court. The only thing that we ask for is that the state-imposed racial segregation be taken off. It is the state-imposed part that affects individual children. Separate but equal is a legal fiction. There never was and never will be any separate equality.
Mr. Marshall, thank you for your arguments on behalf of the plaintiffs. Mr. Davis, you are recognized by the court for 30 minutes to present the defendant's case.
Thank you, Mr. Chief Justice and members of the United States Supreme Court. I am honored to appear before the court this day to represent the interests of the people and elected representatives of the state of South Carolina on issues so fundamental to the right and function of local government as those presented here. It is my sincere intention and expectation that I will be able to address the arguments raised by the appellants in less time than I have been so graciously allotted by the court. My confidence in that regard is certainly buoyed by the extraordinary nature of the ruling which the appellants seek from this court in these consolidated cases. I think if the appellant's construction of the 14th Amendment should prevail here, there is no doubt in my mind that it would catch the Indian within its grasp as well as the Negro. If it should prevail, I am unable to see why a state would have any further right to segregate on the ground of sex, on the ground of age, on the ground of mental capacity. If it may classify for one purpose on the basis of admitted facts, it may, according to my contention, classify it for another. In my view, there are three lines of argument that, when fairly viewed, must lead to the absolute and thorough rejection of each of the appellant's contentions. First, these cases, as presented to this court, are mooted by the consent of my client, the state of South Carolina, to the mandate of the court entered below, which I quote, required the defendants to proceed at once to furnish plaintiffs and other Negro pupils of said district educational facilities, equipment, curricula, and opportunities equal to those furnished white pupils. That mandate has been fully complied with. We have been found to have obeyed the court's injunction. The question is no longer in the case. My client has fully complied with the lower court's order compelling it to ensure, as a matter of priority state policy, that the schools attended by the children of colored families be, in all respects, substantially equal to those attended by children of white families, as this court has historically required in a progression of well-reasoned rulings over nearly a century of judicial consideration of this very same issue. The issues raised by the appellants in that regard are more than simply dead, but they are long, long stale, and no longer in this case. The appellant's appeal of that issue to this court is simply another kick of a long-dead horse in an attempt to wrangle from this court social policy more acceptable to the appellants than that contained in the well-reasoned and socially enlightened decisions of the courts below, which the appellants do not believe have sufficiently invaded the power of state governments to determine the conditions under which the children of their constituents are to be educated. Since the dawn of time, or at least from the first glimmerings of civilized jurisprudence, which depending on one's theory of creation, I suppose one may deem to have different origins, learned judges have consistently insisted that in any given legal dispute, that the facts of a case be examined through the lens of the law, rather than the law modified to breathe relevance into otherwise legally inconsequential circumstance. The question to which I wish to address myself is that Article 14, Section 7 of the Constitution of South Carolina and Section 5377 of the Code, both making the separation of schools between white and colored mandatory, do not offend the 14th Amendment of the Constitution of the United States or deny equal protection. The right of a state to classify the pupils in its public schools on the basis of sex or age or mental capacity or race is not impaired or affected by that amendment. The doctrine in ancient Latin courts called stare decisis, and more recently from the realm of Britannic justice called precedence, is the cornerstone, the pulse, the very spirit of the rule of law, so precious and fundamental to the decisions of this court over its history. In its essence, that doctrine of precedence supposes that the facts of any case are to be evaluated through the prism of the known and existing law, as interpreted throughout antiquity and passed upon by the judiciary only when viewed in that fundamental and consistent light. This fight before this court today is founded in the appellant's request that this court change its historical interpretation of the 14th Amendment to the United States Constitution to read that amendment differently than it has ever been read since the date of its ratification. In the appellant's hope and their desire that in the aftermath of such a ruling, the lesser judiciary may be compelled to use that interpretation of that amendment as a sword against the positive law of the people of all the states, duly enacted as is their sacred right by their founders and their elected representatives, not only those of South Carolina and the other state parties to these cases, but also of the numerous parties, the states not parties to these cases, but whose fates will nonetheless be decided by this court's judgment. I ask this court to consider these questions. Is it not a fact that the very strength and fiber of our federal system is local government in those matters for which local action is competent? Is it not, of all the activities of local government, the one which may most nearly approach the hearts and minds of the people, the question of the education of their young? Is it not the height of wisdom that the manner in which they shall be conducted should be left to those most immediately affected by it, and that the wishes of the parents, both white and colored, should be ascertained before their children are forced to be involved in what may become an unwelcome contact? I respectfully submit to this court that there is no reason assigned here why this court or any other should reverse the findings of 90 years, and during which 90 years a vast body of judicial rulings, wise legislation, and distinguished and learned scholars have supported the constitutionality of segregation. Contrary to the assertions of the appellants, the long-standing policy of segregation in all of the responding states was created under the 14th Amendment and not in violation of it. I want to say something about the evidence offered by the plaintiffs upon which counsel so confidently relies. I see that evidence offered by the plaintiffs, be its merit what it may, deals entirely with legislative policy and does not tread at all on constitutional right. Whether it does or not, it would be difficult for me to conceal my opinion that the evidence is and of itself of slight weight, and is in fact in conflict with other and better informed opinions. Now, while I hope I have not laid out too much territory for the time that is allotted me, I believe I will attack it at seriatim. I want to put this case in its proper frame by reciting what has transpired up to this time so that your honors may be sure that my assertion that South Carolina has fully performed the lower court's order is not an idle boast. When that first hearing was held before Judge Parker, the court entered its decree, demanding us to proceed forthwith to furnish not merely physical facilities, as my friend would have it, but educational facilities, equipment, curricula, and opportunities equal on the part of the state for the Negro as well for the white student. But the court below went further. In order to ensure obedience to its own decree, that court required the defendants within a period of 6 months, and not later than 6 months, to report what progress they were making in the execution of that court's order. Now, I should likely to briefly just summarize what the situation was that those reports exposed. They showed that in the state of South Carolina, under the leadership of its present governor, James F. Byrne, former Associate Justice of this court, and most lately Secretary of State to the United States, there was a surge for educational reform and improvement which I respect has not been exceeded by any other state in the Union. It began with the legislature, which immediately adopted an act providing for the issuance of $75 million in bonds for school purposes. Not a maximum of $75 million, but a maximum at any one time of $75 million. And that to be supported and serviced by a 3% sales tax. And speaking from slight experience, Your Honors, I can assert that that tax escapes very few transactions in the state of South Carolina. That being done, the legislature set up an Educational Finance Commission with the power to survey the educational system of the state, to consolidate districts to better finance, to allot funds to the appropriate districts all over the state in such manner as the commission may find to be appropriate. Now, while I might go further on that subject, I am content to read only 2 sentences of the court below, and this is the opinion of Judge Parker, which you are asked to review. The reports of December 21 and March 3 filed by the defendants, and which are admitted by plaintiffs to be true and correct, and which are so found by the court, show beyond question that defendants have proceeded promptly and in good faith to comply with the court's decree. They add, there can be no doubt that as a result of the program which the defendants are engaged, the educational facilities and opportunities afforded Negroes within the district will, by the beginning of next school year, starting in September, be made equal to those afforded white persons. Well, I come then to what is really the crux of the case. That is the meaning and interpretation of the 14th Amendment to the United States Constitution. We have endeavored in our argument to compress the argument for 2 reasons. The first is that the opinion of Judge Parker below is so cogent and so complete that it seems impossible to add anything to it. The second, perhaps more compelling at the moment, Your Honors, is as Your Honors have so often stated, and you have so often and recently dealt with this very subject, that it would be a work of supererogation to remind you of the cases in which you have dealt with it, or to argue with you, the authors of those opinions, the meaning and scope of the opinions which you have omitted. But as lawyers or judges, if we have ascertained the scope and direction of the Equal Protection Clause of the 14th Amendment, then our duty is done. The rest must be left to those who dictate public policy, and not to the courts. Well, how then should we approach it? Well, I use the language of this court. An amendment to the Constitution should be read, you have said, in a sense most obvious to the common understanding at the time of its adoption. For it was for public adoption that amendment was first proposed. Still earlier, you have said that it is the duty of interpreters to place ourselves as nearly as possible in the condition of the man who framed the instrument. Well, what was the condition of the man who framed the 14th Amendment to the United States Constitution? The resolution proposing the amendment, the 14th Amendment to the United States Constitution, was proffered by the United States Congress in June of 1866. In the succeeding month of July, the same Congress proceeded to establish or to continue segregation in the public schools of the District of Columbia. And from that good day to this one, the United States Congress has not wavered in that policy. It has confronted attack upon segregated schools in the District of Columbia repeatedly. In fact, during the life of Charles Sumner, over and over again, he undertook to amend that law of the District of Columbia, and again he was defeated. Equal protection in the minds of the Congress of the United States did not and does not contemplate mixed schools as a necessity. Now, while it is true that in the Constitution of the United States there is no Equal Protection Clause, it is also true that in the 14th Amendment, well, that amendment was primarily addressed to the states. But it is not conceivable that the Congress, which submitted that amendment, would have turned around and forbidden the states to employ an educational scheme which Congress itself was persistent in employing in the District of Columbia. I therefore urge that the action of Congress is a legislative interpretation of the meaning and scope of this amendment and a legislative interpretation of a legislative act. No court, I respectfully submit, is justified in ignoring. What states are involved here? What did they think at the time that the 14th Amendment was adopted? Well, at the time that amendment was adopted, there were 37 states in the Union. 30 of them had ratified the amendment at the time it was proclaimed in 1868. Of those 30 states, 23 either had then or immediately installed separate schools for white and colored children within their public school systems. Were they violating the amendment that they had so recently adopted and solemnly accepted? Were they conceiving of it in any other sense than it did not touch their power over public schools? Well, how do the states stand today? 17 states in the Union today provide for separate schools for white and colored children, and 4 others make it permissive with their school boards. Those 4 states are Wyoming, Kansas, New Mexico, and Arizona. So you have 21 states now, Your Honors, which conceive it within their power and their right to maintain separate schools if it suits their policies. We next turn to the judicial branch, and it has spoken on the question, not only through this court, but the lower courts as well, perhaps with more repetition and in more cases than any other single separate constitutional question that now occurs to me. What does this court say? Well, I repeat myself, I guess, that I shall not undertake to interpret for Your Honors the scope and weight of your own opinions. But in Plessy v. Ferguson, Cummins v. Richmond County Board of Education, Gonglum v. Rice, Berea College v. Kentucky, Sippuel v. Board of Regents, Gaines v. Canada, Sweat v. Pena, and McLaren v. Oklahoma, and there may be others for all I know, this court has spoken consistently in the most clear and unmistakable terms to the effect that this segregation is not unlawful. And so the record reads. In closing, it is our strong contention that no court in modern times should substitute its judgment on the interpretation of the Equal Protection Clause of the 14th Amendment for the interpretation given it by its authors and by the states that ratified it, with the full intent and expectation that the decision of that court, of that state, of that school board, of whether children of white and colored families should attend the same or separate schools should be left exclusively and solely to the state governments. I respectfully submit that nothing urged by the appellants, not their social data, which after all is considered was prepared by persons never compelled to consider from a position of social responsibility the issue of segregation as a matter of governmental concern, not the appellant's invitation to this court to reverse its clear decisions of nearly a century's time, and not the appellant's plea that this court legislate from here in Washington, D.C., the educational policies and standards of the state of South Carolina, and by so doing substitute its judgment, wise though it may be, for the legislative policies of the democratically elected representatives of the people of South Carolina and all the other states. The education of the young is strictly and rightly a matter for determination by the parents of those to be educated through their majority voice in state legislative affairs.
Mr. Davis, thank you for your argument on behalf of the defendants. Justice Frankfurter, you're recognized for a question for Mr. Marshall.
Thank you, Mr. Chief Justice. Mr. Marshall, how do you respond to Mr. Davis's argument that the United States Congress proposed the 14th Amendment with regards to the issue of slavery, and that Congress in no way intended the 14th Amendment to address public school segregation? As a matter of fact, most states in the 1860s were not significantly involved in funding public schools.
Mr. Marshall.
Thank you, Mr. Chief Justice Warren. Mr. Justice Frankfurter, in anticipation of the question, I have prepared a written response. Your Honors, the framers were formulating a constitutional provision setting broad standards for determination of the relationship of the state to the individual. They could not list all the specific categories of existing and prospective state activity which were to come within the constitutional prohibitions. The broad general purpose of the amendment, the obliteration of race and color distinctions, is clearly established by the evidence. So far as there was consideration of the amendment's impact upon the undeveloped educational systems then existing, both proponents and opponents of the amendment understood that it would proscribe all racial segregation in public education. We have examined the court's interpretations of the Equal Protection Clause in two cases between 1873 and 1880. In the slaughterhouse cases of 1873, the court ruled, and I quote, "The existence of laws in the states where the newly emancipated Negroes resided, which discriminated with gross injustice and hardship against them as a class, was the evil to be remedied by this clause, and by it such laws are forbidden." End of quote. In Strouder versus West Virginia, 1880, the court held, and I quote, "It, the 14th Amendment, was designed to assure the colored race the enjoyment of all the civil rights that under the law are enjoyed by white persons, and to give to that race the protection of the general government in that enjoyment, whenever it should be denied by the states. It not only gave citizenship and the privileges of citizenship to persons of color, but it denied to any state the power to withhold from them the equal protection of the laws, and authorized Congress to enforce its provisions by appropriate legislation. The law in the state shall be the same for blacks as for whites. A law to single out blacks is practically to put a brand upon them, an assertion of their inferiority. Provisions requiring segregated schools were written into state constitutions and statutes. Negroes have been driven from participation in political affairs, and our veritable maze of Jim Crow laws has been erected to keep the Negro in his place of inferiority, all within impunity. There was no longer any need to pretend either that Negroes were getting an education equal to the whites or were entitled to it. We submit that this court cannot sustain these segregated schools or these laws under any separate but equal concept unless it is willing to accept as truth the racist actions of the perpetrators of segregation and to repeat the tragic error of the Plessy Court, supporting those who would nullify the 14th Amendment on the basic tenet of our way of life, which it incorporates. We respectfully suggest that it is the obligation of this court to correct that error by holding that these laws and constitutional provisions which seek to condition educational opportunities on the basis of race and color are historical aberrations and are inconsistent with the federal Constitution and cannot stand. The separate but equal doctrine of Plessy versus Ferguson should not and now be forever overruled. The 14th Amendment requires that a decree be entered directing that appellants be admitted forthwith to public schools without distinction as to race or color. There is no equitable justification for postponement of appellants' enjoyment of their rights. Previous debates show conclusively that the 14th Amendment gave constitutional sanction to the principle that states are deprived of all power to enforce racial distinctions in governmental functions, including public schools. The appellants in this case believe that the 14th Amendment's primary purpose was to complete the emancipation provided by the 13th Amendment by ensuring to Negro equality before the law. The issue is not whether states have the right to segregate, but whether individual rights are being violated by racial segregation. The 14th Amendment guarantees every American equal protection. History has made segregation by race very different from other state-imposed distinctions. Only Negroes are being taken out of the mainstream of American life. I know in the South, where I spend most of my time, you will see white and colored kids going to school. Down the road together, they separate and go to different schools. And they come out again and they play together. I do not see why there would necessarily be any trouble if they went to school together. The NAACP urges that the 14th Amendment was intended to write into the organic law of the United States the principle of absolute and complete equality in broad constitutional language. A review of the legislative history of the 14th Amendment in the states demonstrate this. The old Confederacy, as directed by Congress in 1867, adopted constitutions and ratified the 14th Amendment. Almost all states discussed segregated schools and specifically rejected them. And no state enacted a law compelling racial segregated schools until after the state's readmission. In fact, South Carolina and Louisiana did not segregate their schools until 1895 and 1898, respectively, in the Plessy era. In fact, 22 of 26 Union states ratified without congressional compulsion, but only 2, both former slave states, West Virginia and Missouri, kept segregated schools. All but 2 others had desegregated schools within a few years of ratification, only New Jersey and Pennsylvania delaying until 1881. Some had desegregated earlier, such as Massachusetts in 1855, while some, Maine, Vermont, Wisconsin, and Minnesota, had never had segregation. Only Indiana and Kansas enacted laws permitting localities to segregate their schools. Delaware, Maryland, and Kansas refused to ratify. Of the 3, only Delaware legally mandated school segregation, and while the latter 2 created dual racial systems, neither forbade integration. California neither voted the amendment up or down, and that state's racial segregation practices focused on Asians and not ex-slaves. In all the state legislatures, there was clear discussion of the significance of the Equal Protection Clause and segregated schools. The heart of the answer is that this very court, has previously ruled discrimination was not constitutional. Time and again, the Supreme Court has ruled that if a state has deprived a Negro of the right which he would have freely enjoyed if he had been white, then that state's action violated the 14th Amendment. The only way the court could allow blacks to be segregated in public schools was if it concluded that Negroes are inferior to whites. School justification for continued school segregation is the desire to keep the people who were formerly enslaved as near to that stage as possible. It seems to me that the significant factor running through all these arguments up to this point is that Negroes are taken out of the mainstream of American life in these states. There is nothing involved in this case other than race and color. We must once again emphasize that under our form of government, these individual rights of minority people are not to be left to even the most mature judgment of the majority of the people, and that the only testing ground as to whether or not individual rights are concerned is in this court. We had hoped that we had put into the evidence, into the record, the type of evidence which we consider this court to have considered in the Sweat and McLaren cases, to demonstrate that at the elementary and high school levels, the same resulting evil which was struck down in these cases exists for the same reasons at the elementary and high school levels. And I say at this moment that none of that has been disputed. Your honors, it is our dedicated belief that the Constitution of the United States is colorblind. The rights of the minorities have been protected by our Constitution, and the ultimate authority for determining that is this court. I think that is the real difference as to whether or not I, as an individual, am being deprived of my right is not legislative, but judicial. Thank you.
Justice Douglas, you're recognized for a question to Mr. Davis.
Thank you, Mr. Chief Justice. Mr. Davis, opposing attorney Mr. Marshall has presented sociological and psychological data to this court that legalized racial segregation of public schools produces a detrimental effect upon the hearts and minds of colored children, and that generates a feeling of inferiority, unlikely ever to be undone. What is your response to this?
Mr. Davis.
Well, Mr. Justice Douglas and Mr. Chief Justice, I appreciate the opportunity to respond to that question. However, unlike my learned colleague, I have not prepared a response because, frankly, I consider that testimony to be so much fluff that would not prove persuasive to a court and should not prove persuasive to any court, as it was not persuasive to the court below, but to the extent that the court's question requires a direct answer. I guess we can have a look at what the actual witnesses said. If we look at that particular witness, Dr. Clark. Now, Dr. Clark professed to speak as an expert and an informed investigator on the subject of what your question was. That is, what is the overall lingering effect of segregation upon the hearts and minds of young children of colored race or of the white race, given the legally mandated segregation that we encounter in South Carolina and so many other states. But there are two things that are most notable about Dr. Clark's opinions and about the doctors and expert witnesses themselves. First of all, not one of them is under any official duty in the premises whatsoever. Not one of them has had to consider the welfare of the people for whom they are legislating or whose rights they were called on to adjudicate. And only one of their experts professes to have even the slightest knowledge of conditions in the states where segregated schools are now being maintained. Only one of the plaintiff's experts professes to have any knowledge whatsoever of the conditions within the 17 segregating states, and yet they render these opinions to which the court refers. Dr. Clark's investigation consisted of visits to a school called Scotts Branch, primary and secondary school at Scotts Branch, which he undertook at the request of counsel for the plaintiffs. It was not an independent investigation. He called for him for the presentation to him, asked the school to bring him 16 pupils between the ages of 6 and 9 years of age. And he applied to them what he devised and what he was pleased to call an objective test. That consisted of offering to them 16 white and colored dolls and inviting them to select the doll they would prefer to play with, the doll they thought was nice, the doll that looked bad or the doll that looked most like themselves. Now, Dr. Clark ascertained for his own opinion that out of that battery of tests, that 10 out of those 16 students preferred the white doll. 9 thought the white doll was nice. 7 thought it looked like themselves. 11 said the colored doll was bad. And 1 that the white doll was bad. And out of that intensive investigation of presenting 16 dolls to 16 children, Dr. Clark reaches the opinion that the plaintiffs espouse here before this court and before the court below. That is a sad result. We are invited, as you have been, Your Honors, to accept that as a scientific conclusion. But I'm reminded in that context of the scriptural saying, "Oh, that mine adversary has written a book." And Professor Clark, he has written a book with the assistance of his wife, has written on this subject often, and has described a similar test that he submitted to colored pupils in the northern and non-segregated schools. Now, when Dr. Clark took his test to the northern schools, he found that 62% of the colored children in the South chose a white doll, 72% of the colored children in the North chose the white doll. 52% of the children in the South thought the white doll was nice, but 68% of the children in the North thought the white doll was nice. 49% of the children in the South thought the colored doll was bad. 71% of the children in the North thought the colored doll was bad. Now, these latter scientific tests were conducted in non-segregating states, and with those results compared, what becomes the blasting influence of segregation that Dr. Clark has so testified or so eloquently testified to? In sum, Mr. Justice Douglas, we see no relevance to the sociological data presented to the plaintiffs to this court, and ask this court to consider it just so much fluff.
Thank you, Mr. Davis. Mr. Marshall, Mr. Davis, we will be leaving now to deliberate your arguments.
Please rise. You may be seated. Would you please rise?
Mr. Marshall, Mr. Davis, we have reached a unanimous decision, which I shall read. Welcome then to the question presented. Does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe it does. Intangible factors involved in the separation of students of similar age and qualifications solely because of their race need very serious consideration. Such segregation of white and colored children in public schools has a detrimental effect upon the colored children, an impact that is greater when it has the sanction of law. It generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we hold that the plaintiffs and others similarly situated for whom these actions have been brought are, by reason of segregation, complained of, deprived of the equal protection of the law guaranteed by the 14th Amendment. We have now announced that such segregation is a denial of the equal protection of the laws in order that we may have the full assistance of the parties in formulating decrees. The cases will be restored to the docket. Thank you, Mr. Marshall and Mr. Davis, for your arguments. We stand adjourned.
Ladies and gentlemen, I want to express our committee's deep appreciation to all those who participated in today's program. I was so impressed that we will be using this in political science classes at North Idaho College. I do want to, first of all, introduce to you the two individuals that presented to the court today. First of all, I would like for him to stand, our good friend from Spokane, Bob Bartlett, who's a sociologist. He is on the faculty at Gonzaga University, and we've been friends a long time. He's just a great attribute to that institution, and he serves on the Martin Luther King Committee. Unfortunately, we won't have time for questions because they have a luncheon, and then we have TV shows. You were just totally eloquent. We thank you so much. They had done so much research on this court case. Secondly, I'm equally pleased to introduce to you an attorney from Coeur d'Alene, Rich Cook. I have a bias here. Rich is a former student of mine, and when he was here, he had a lot of court cases, and he too was very eloquent. Rich was presenting in my class a criminal trial, and he said to me one day, he said, after doing this, I know what I want to do, and that's to be an attorney, and I will not stop until I'm an attorney. And you've been very successful, Rich. We thank you. And I do want to thank Dr. Michael Burke. He's our president of our institution. I've said about him on a number of occasions when he came here, he wasn't here a day until I knew his passion and commitment to human rights. And Dr. Burke, as one who's been here a long time, I'm so totally grateful to you. You walk your talk, and thank you for serving as Chief Justice today. It was very appropriate because it was Chief Justice Earl Warren that turned the court around. It was first vote was 6-3, and he convinced the court to be 9-0 because of the reaction. And I also want to introduce all the others who I'm very, very proud of. These are all my students. They were drafted out of my 11 o'clock class, which meets on Monday, Wednesday, and Friday. You were great, and thank you, too, for the questions. There's some really successful people here in the future also, and some of them are already practicing law. In fact, one of them got in lots of trouble last week on evidence, but that's how they learn. We're so proud. We did make a little change in how the court operates. Usually the court presents each side 1 hour to argue before the court. And what didn't happen here today, which almost always happens to the court as they are presenting, the court interrupts them really a lot and asks them questions. And we wanted to make sure that you got to hear the argument. We will be sending this tape, as we do all of our tapes, to our guests. And Bob, if they can use that at Gonzaga, it'd be great. I am so, so proud of you. And at 1 o'clock, there'll be a panel over at the sub. And again, let's thank all of our special people.